Check 1 2. Checking 1 2. Check 1 2. Testing 1 2.
Testing 1 2. Testing 1 2. Testing 1 2.
right, good afternoon. I'm Dean Jessica Berg, and my role is very simple. I get to say welcome this afternoon to our Spangenberg Center for Law, Technology, and the Arts Distinguished Lecture. The lecture is part of an extraordinary gift that was given to the law school by the Spangenberg Family Foundation, established by Audrey and Eric Spangenberg, who is a graduate of the law school. I get to turn the podium now over to Professor Craig Nard, who is our inaugural director of the Spangenberg Center, who will introduce our very distinguished lecture.
Good afternoon, everyone. Thank you for being here this afternoon. Those of you who practice in the area of IP or bump up against its borders in that space are certainly aware of our distinguished lecturer today. Kate O'Malley is a native of Cleveland, spent much of her personal and professional life here, went to this law school, was a graduate Order of the Coif, and then went on to a Sixth Circuit clerkship, and from there to Jones Day and Porter Wright, before being tapped to be the general counsel or chief counsel and chief of staff for then Attorney General Lee Fisher. And from there, President Clinton appointed her to the Northern District of Ohio here in Cleveland, which I could tell you, when I was practicing and started getting into patent law, Judge O'Malley very quickly gathered a reputation for being maybe one of a handful of district court judges of the 94 districts we have in this country of getting patent law at a deep level, understanding its nuances and complexities. And I would talk to litigators, and I would ask, well, who do you have? And they would say, well, Kate O'Malley. And they knew they were in for a really good trial, a fair trial, but somebody who just got it. And as a former patent litigator myself, there's nothing like a district court judge who just gets it. You may win, you may lose, but it's wonderful. When she was nominated by President Obama in 2010 to go to the Federal Circuit, that was a bit of a mixed blessing for us. Having her leave the district court was clearly a loss for the Northern District, but a student of patent law would certainly rejoice in her going to the Federal Circuit, where some of her opinions reflect much of the nuance and intelligence that occupied her district court opinions. But now she has a bit more influence. And so we're really happy that she's been on that court. Patent law and the court are better for it. Today she's going to talk to us a bit about innovation and IP. I very much look forward to her thoughts and welcome her home in a sense. Kate?
You notice Craig has the mic way high, and I need it way low. Thank you. I always get the best welcomes in Cleveland, and it always makes me feel very good. I want to thank all of you for being here, especially given the timing of the Tribe game today. I really appreciate the diehards. Having been a lifelong Clevelander and a diehard fan of every Cleveland sports team, which, as you know, is not always that easy, I've been one of those people that's always torn about whether to watch the games when one of my teams is playing, because I've seen so many losses that for some reason I started to blame it on myself. Oh, I'm watching, so that's why they're losing. So I always am torn about whether I watch or not. So I actually think that while some of you may view it as a little bit of a sacrifice to have to be here instead of watching the game, you should think of it as giving one for the team, because by being here and giving me an audience to give this lecture, you're preventing me from watching it. So they'll probably win. Turning to the lecture, I am going to talk about a topic of my choosing that I feel pretty strongly about, but when I'm done, I'm happy to entertain questions on anything that you want to talk about. So, we've all heard the view that history is bound to repeat itself. A wise caveat to that belief is that history is bound to repeat itself unless we learn from it. Our experience with the patent system to date evidences cycles of repetition. And there are few glimpses of wisdom having reared its head in that experience. Perhaps it's time that we start thinking outside the box, or outside the cycle of repetition, if you will. The development of our current patent system began with the birth of our nation. Before the Constitution, the nation had no centralized mechanism for granting patent rights. And there's no indication that the delegates that put together the Articles of Confederation, which was designed more with giving power to the states and less to a centralized federal government, even considered whether a strong patent system was wise. Some states did grant patent rights during that time in an effort to encourage and reward, quote, men of learning and genius. Note, only men. But according to a later Senate report written in 1836, it became clear that the states could not actually provide adequate encouragement to incentivize inventors because they couldn't promise that other states would honor any patents that they granted. The report concluded that this lack of incentive resulted in, quote, very little progress on this side of the Atlantic. With ratification of the Constitution in 1788, the new federal government was given the power it needed to incentivize innovation. Article 1, Section 8, Clause 8 of the Constitution gives Congress the power, quote, to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries, end quote. Contemporaneous records, such as Madison's notes, indicate that members of the Constitutional Convention adopted this clause without any real debate, although some have interpreted this as a lack of interest on the part of those present. Other indications suggest that the framers actually considered it so important that they believed it to be beyond debate. Soon after ratification, George Washington gave his first State of the Union address in 1790. Although the address comprised only about 1,000 words, he included this entire passage related to patents. The advancement of agriculture, commerce, and manufactures by all proper means will not, I trust, need recommendation. But I cannot forbear intimating to you the expediency of giving effectual encouragement as well as to the introduction of new and useful inventions from abroad as to the exertions of skill and genius in producing them at home. Nor am I less persuaded that you will agree with me in opinion that there is nothing which can better deserve your patronage than the promotion of science and literature. In one of its first 3 statutory enactments, Congress passed the Patent Act of 1790. The act called for a patent to issue for any useful art, manufacture, engine, machine, or device, or any improvement thereon, not before known or used. The act had the inventor present a petition to the Secretary of State, the Secretary of the Department of War, and the Attorney General of the United States, who jointly would consider the patent applications. And any 2 of these 3 could grant a patent if they found the invention sufficiently useful and important. The first patent board, notably, was Thomas Jefferson as Secretary of State, Henry Knox as Secretary of War, and Edmund Randolph as the Attorney General. The board was to perform an in-depth analysis of the applications. It was to meet, to discuss the applications, and to hold hearings with applicants. It even actually participated in interference proceedings where multiple people sought the same patent. Now, as a member of the first board, Thomas Jefferson was a particular advocate of the patent system and its accompanying incentive for innovation. Records of his letters show that he believed an inventor ought to be allowed a right to the benefit of his invention for a certain time. He said, "Nobody wishes more than I do that ingenuity should receive liberal encouragement." Despite this sentiment supporting the patent system and its beneficial effects on innovation, the 3 members of the patent board soon found that the work in analyzing the applications was a bit much. Only 57 patents were granted between 1790 and 1793, but even that small number caused Jefferson, Knox, and Randolph concern over the amount of time these patent duties took away from their other obligations to our young country. And applicants expressed concern regarding the amount of time it took to get a patent. In other words, some felt that the system set up by Congress in its first act meant that the inventors were not receiving sufficient or timely protection for their inventions, and that the patent system was not indeed promoting the progress of useful arts and science. In response to these concerns, Congress amended the Patent Act in 1793. The 1793 Act sought to decrease the amount of work required and to improve the rapidity with which applicants could obtain protection for their inventions. It did this by completely removing any review by a patent board. Instead, patent applications received no substantive examination. The new act consolidated the oversight of patents within the purview of the Secretary of State, but it provided the Secretary of State with no power to reject a patent. Everyone who applied for a patent would receive one as long as they paid the necessary duty. This new Patent Act, as you can imagine, this system turned out to be a disaster. The incentives to innovate were largely defeated by those who sought to abuse the law. The 1836 Senate report concluded that the 1793 Act harmed innovation. It determined that a considerable portion of the patents granted were worthless or void or even fraudulent. The excess of granted patents flooded the economy with monopolies that infringed on one another and resulted in an alarming increase in patent litigation that was, according to the 1836 report, quote, onerous to the court, ruinous to the parties, and injurious to society. The Senate report also found that it became common for frauds to copy patented machines just in order to obtain their own patents on those very same inventions. Because the Secretary of State couldn't reject these applications, the government granted the applications as a matter of course, and the claimed inventors went forth selling their patent rights to the public, who only later came to learn that they had purchased useless rights. This speculation in patent rights became a regular business, with hundreds of thousands of dollars paid for void patents, often patents held by what we would call today non-practicing entities. The system created by the 1793 Act created a climate in which, quote, patents, even for new and meritorious inventions, were so much depreciated in general estimation that they were of but little value to the patentees, and the object of the patent laws, that of promoting the arts by encouragement, was in a great measure defeated. In order to recreate an innovation incentive, Congress tried again, amending the Patent Act in 1863. The new law established a patent office as a distinct entity within the Department of State, with a commissioner of patents as its head. It mandated a systematic examination method for reviewing patent applications so that the patent office could ensure the validity of an invention prior to issuing a patent. The act required an applicant to file a specification, a drawing, and even provide a model, if possible. It required the applicant to provide a detailed description so that anyone could construct and use the invention after the expiration of the patent. And the Patent Office was tasked to undertake an examination of the application to discover whether the alleged invention had been invented, published, or used previously. Only if the Patent Office determined that the application provided for a novel, original, and useful invention would the commissioner grant the patent. Under these terms, Congress attempted to restore respect for and trust in the patent system so that the system could perform its intended purpose, that of promoting innovation. The 1836 report expressly noted that it is not at this day to be doubted that the evil of the temporary monopoly is greatly overbalanced by the good the community ultimately derives from its toleration, and that the new bill should be designed to better suit the law of patents, quote, to the present condition of the arts and the altered circumstances of the community. The pendulum began to swing back to a place where patent quality was considered central to a functioning patent system. Now, the newly refined patent system was deemed central to America's progress. Abraham Lincoln, the only president to have obtained a patent, gave a speech in 1859, just before becoming president, in which he discussed what he believed to be the key developments facilitating the inventions and the discoveries for which the new country was becoming known. These developments he characterized as of peculiar value, and he said they included the arts of writing and printing, the discovery of America, and the introduction of patent laws. In that same speech, President Lincoln described the patent system as the development that added the fuel of interest to the fire of genius in the discovery and production of new and useful things. Others soon echoed President Lincoln's sentiments, lauding the patent system's impetus for innovation. While attending the 1876 Centennial Exhibition in Philadelphia, Sir William Thomas, the president of the Mathematical and Physical section of the British Association, stated that, quote, if Europe does not amend its patent laws, America will speedily become the nursery of useful inventions for the world. Kurihito Takahashi, Japan's Assistant Secretary of State, along with a special commission from Japan, visited the United States in the late 1800s. During that visit, they toured the patent office. Mr. Takahashi later said that he and his commission wished to discover quote, what it is that makes United States such a great nation, and we investigated and we found it. It is patents, and we will have patents. Sir Henry Sumner Maine, a British jurist and legal historian, acknowledged that the federal grant of patent rights was one of the, quote, provisions of the Constitution of the United States which have most influenced the destinies of the American people, end quote, and that because of it, the United States was the first in the world for the number and ingenuity of the inventors by which they have promoted the useful arts. Now, despite all this praise, the 1836 Patent Act, which was well designed, indeed it served as the design for our patent system all the way until the America Invents Act in 2011, still had problems that continued, and those problems continued to plague the system. The lingering effect of the bad patents that flooded the system in the country's early years left a bad taste. Many in the community and many judicial officers showed a disdain for patents. Even valid patents were met with resistance when owners sought to enforce them, and the geographically dispersed nature of our courts led to wide disparities in the treatment of patents, even the very same ones. While many changes to the patent laws were considered and proposed in the early part of the 20th century, Congress ultimately decided that codifying current law in a clearly detailed statutory scheme would suffice. With codification, it was hoped that the differences in judicial treatment of patents would narrow and a measure of certainty might be established. Thus, we were given the Patent Act of 1952. The Act itself explained that no basic changes to the general character of the patent laws had occurred since 1836, and that the Act did not intend to make such changes either, except at the margins. In 1967, the Senate published a report prepared by the President's Commission on the Patent System. In the report, the Commission unanimously agreed that a patent system today is capable of continuing to provide an incentive to research, development, and innovation. The Commission stated that it had discovered no practical substitute for the unique service that the patent system continued to offer by promoting innovation. It conceded, however, that the long pendency of patent applications and great uncertainty and considerable expense involved in the enforcement of patents plagued the current system. And notably, it concluded that changes to the system should be made in order to, quote, raise the quality and reliability of the U.S. patent. The 1967 report's recommendations for change are really interesting. Among other things, it recommended a first-to-file system, like that used in most countries around the world, and suggested that other changes be considered to align our approach to patent law with an international system for the protection of intellectual property rights. It also recommended that patent protection not be afforded for design patents, plant patents, or any what it called programming patents. On this last point, the report concluded that computer code was and should remain protected by copyright, but that all other programming should be unprotected because its development already had occurred rapidly without the need for patent protection. In other words, it saw software as an innovation that had its own incentives, making patent protection unnecessary to its further and rapid development. Now, imagine how much angst, uncertainty, and judicial resources would have been saved if these suggestions had been adopted. The report also suggested that the PTO's funding not be diverted, that the quality of the examination process be improved with additional training, and that a 6-month post-grant review period be adopted. How prescient do these ideas seem now? In fact, though, nothing ever came of the 1967 report, at least until a few of its suggestions found their way into minor congressional amendments in 1984, and more found their way into the AIA. Unfortunately, we also saw an insufficient benefit from the codifications in the 1952 Act. Because the Act expressly said it was adding nothing new to the patent laws, the attitudes of judicial officers and those in the community did not change. Patents continued to receive little respect in many parts of the country, and the judicial circuits exhibited a wide disparity of views regarding the quality and enforceability of patents litigated before them. Patent owners had no ability to predict whether and where their patents would be enforced, let alone whether they would be able to recoup the costs of their inventions. I recently heard a barrister from the United Kingdom describe the world of US patent litigation in the 1970s. He said patents in the US were treated as unsavory things, and law firms saw them as so unlikely to be of value to their clients that they assigned patent cases to what he called dweebs with no trial experience. So those were his words, not mine. So the Federal Circuit was formed in 1982 to address this lack of uniformity and uncertainty regarding the enforcement of patent rights. Congress realized that a lack of consistency in how the patent law was interpreted and applied endangered innovation by making it difficult to rely predictably on the rights patents conveyed. The Federal Circuit was formed to limit forum shopping and reduce inconsistencies among the circuits. As explained in a statement from the Carter administration, the creation of the Federal Circuit would expand the federal judiciary system's capacity for definitive adjudication of national law and thereby, in part, encourage industrial innovation. Congress was right to an extent. By its very existence, the Federal Circuit went a long way toward achieving the congressional goals that led to its creation. Once declared not invalid by a Federal Circuit judgment, a patent retained that status on a nationwide basis unless the Supreme Court said otherwise. And if a given product infringed a patent claim in one state, it infringed in them all. During its early years of jurisprudence, the Federal Circuit also was far more protective of the rights granted in patents than most regional circuits had been. This led inventors and businesses to return to the patent system. Seeing value in patent protection, both from an offensive and a defensive standpoint, applications and enforcement actions both soared. To some extent, however, we ultimately found ourselves in the same thicket in which the country had been in the early 1800s. The PTO was so flooded with applications and was under such pressure to move its backlog that meaningful examination of patent applications suffered. Patents were issues that never should have been authorized, and often patents covering virtually the same technology were issued to more than one applicant. The numbers are telling. In 1967, the PTO received 90,000 patent applications and granted 69,000 patents. The number of applications had nearly doubled to over 176,000 by 1990, and the number of patent grants was up to over 100,000. By 2013, the PTO received over 600,000 applications and granted over 300,000 of those. And in 2015, the numbers increased once more. This explosion of applications and grants was accompanied by an expansion in the fields of technology in which people and companies sought patents. Even into the late 1970s, mechanical inventions made up the majority of all patents issued by the PTO. At least one study found that this prevalence in mechanical inventions dropped significantly by the late 1990s, at which point mechanical inventions accounted for less than 1/3 of the patents granted by the PTO. Instead, this time frame saw meaningful increases in the number of patents granted for, among other things, computer-related inventions, including those very programming matters that the 1967 report recommended not receive patents, semiconductors, medical devices, pharmaceutical products, automotive inventions, and others. And many of these patents were either granted to entities with no intention of or wherewithal to practice the claimed inventions, again, creating a speculation or an incentive for speculation in patents that had not been seen for almost 200 years. We were also brought back to a world where interferences, re-exams, and litigation first, to a degree that, in the now echoing words of the 1836 Senate report, were again, quote, onerous to the court, ruinous to the parties, and injurious to society. Again, the numbers help paint the picture. In its first year, the Federal Circuit entertained appeals from district court judgments in only about 175 cases. This despite its nationwide jurisdiction over patent actions arising in all district courts. The patent cases that the Federal Circuit did receive accounted for less than 30% of its overall docket. Fast forward to fiscal year 2015, where the Federal Circuit entertained appeals from district court judgments in 632 cases. District court patent filings rose to almost 6,000, and appeals from PTO decisions were up to 476, a 600% increase in 4 years. Patent cases now make up 60% of the court's docket, actually over 60% the last time I checked. And two familiar problems emerged. Corporations began to feel the financial burdens of patent litigation, and questions regarding the predictability of one's ability to protect their intellectual property rights were renewed. Patent litigation had become overwhelming to many business owners and inventors and came to be viewed as a deterrent to the very innovation that Congress sought to encourage when it formed the Federal Circuit. Congress again responded to the cry for change. With the AIA, Congress acted to redefine the patent laws in ways not done since 1836. Again, Congress couched the need for reform in the mantle of promoting innovation. As Senator Leahy stated, a balanced and efficient intellectual property system that rewards invention and promotes innovation through high-quality patents is crucial to our nation's economic prosperity and job growth. Innovation has always been at the heart of America and American success. From the founding of our nation, we recognize the importance of promoting and protecting innovation. The patent system plays a key role in encouraging innovation and bringing new products to market. The discoveries made by American inventors and research institutions, commercialized by our companies, and protected and promoted by our patent laws have made our system the envy of the world. Now, the belief behind the AIA was that by improving patent quality and speeding up the processes by which the quality of already issued patents could be reassessed, the entire patent system would be strengthened. Are you beginning to see a pattern here? It keeps repeating itself. Now, although Congress purported to promote innovation when passing the AIA, many now argue that the AIA has not fully done that it has actually thrown out the baby of good inventions in need of serious investment in research and development with the bathwater of undeserving patents. And its implementation has taken us even farther out of step with the international world of IP. No other country employs different standards of claim construction or different burdens of proof when assessing the validity of issued patents in administrative and court tribunals. They, in fact, think our system is out of whack. The question being posed now, both here and on an international level, is whether we have swung the pendulum too far. Whether patent protection is being so diluted that this country's system is no longer sufficiently robust to protect and foster innovation. Is the U.S. losing its preeminence when it comes to encouraging innovation as other countries speculate? So what do? Do we keep always, in the name of promoting innovation, swinging back and forth between promoting an expansive patent system and creating processes that disfavor broad patent protection? Or is it time for a more nuanced approach? One that will, rather than swing the pendulum back and forth, recognize the need for more targeted reform. There's no doubt that as some of the proposed bills in Congress reflect, Congress is tempted to rethink the free rein the PTO was given to implement the AIA and to assess whether the PTO is really doing what is consistent with what Congress intended. That is, whether the AIA will ultimately incentivize innovation rather than squelch it. Beyond that, though, perhaps it's time we realize that our one-size-fits-all system may not really work to incentivize innovation. While I'm not the first to think of this, it has for some reason gotten almost no traction over the years. If we are to provide patent protection for software and other programming-related inventions, which even after Bilski and Alice we still do, perhaps that protection should be different in kind. If, as the 1967 report noted, those kinds of technological improvements continue apace without great need for patent protection, or as some scholars have pointed out, with far shorter times to market, perhaps the length of patent protection for such innovation should be shortened, commensurate with the investment of time and money they reflect, the swiftness with which the technology changes, the ease with which the technology can be designed, or the public benefit flowing from the advancement. Rather than 20 years of IP protection, perhaps 3 would suffice, or even 5 for certain categories of innovation. Or perhaps we should require, as Professor Mark Lemley has suggested, that the public disclosure of such high-tech inventions be more definite. We could require functional claiming for programming or other high-tech inventions so that the claims are both clear and narrow. All of this could help assure that older patents do not unintentionally cover later developments that were never really envisioned by the original inventor. These limitations could afford necessary protections for an inventor's discovery while ensuring that we do not discourage later invention in that space. On the other hand, where technologies such as first-in-class medical devices, pharmaceuticals, and biosimilars take longer to develop, require far greater upfront cost, and provide a different character of benefit to the public, a broader scope of protection may remain appropriate. Because of the increased time and necessary significant expense associated with these inventions, these and similar industries may require a greater incentive and greater level of patent protection if they are to thrive and continue to innovate. So too, smaller or academic innovators may have no incentive or funding source other than patent protection to move from innovation to innovation. While those entities capable of manufacturing and marketing embodiments of their inventions are less in need of, and their continued innovation is less dependent upon, long-term patent protection. A congressional report on innovation prepared in connection with the AIA acknowledged the existence of, quote, differing patent values in distinct industries. It recognized experience and economic research suggest that distinct industries encounter the patent system in different ways. It noted that the reasons for diverging assessments of the patent system include the cost of research and development, the technological risk associated with such research, and the availability of effective non-patent means of protection. These differences necessarily create different views of the incentives needed from the patent system by different industries. Despite this recognition, no effort to differentiate the desired and useful level of patent protection on an industry-wide basis is evident anywhere in the AIA. And it's my understanding that the current PTO director has resisted such differentiation every time asked about it by Congress. Now, I can't resolve this debate for Congress in the time I have left, but I believe it may be time for Congress to consider more targeted changes to the patent system that will better acknowledge the disparate industries and technologies and understand that they are seeking protection from patents in different ways. A recent article by John Allison, Mark Lemley, and David Schwartz explains that based on the findings of the authors, it is entirely possible that pharmaceutical patent owners insisting that patents serve as strong and valuable drivers of innovation may be just as correct in their assessment as software companies are when they insist that patents are overclaimed, often invalid, and operating as a disincentive to rapid innovation. Our courts can and have begun to acknowledge differences among industries. We have recognized that an exclusive right to practice one's invention does not always translate to the right to exclude others, where the other is not, in fact, practicing the invention, or there is a substantial need for the allegedly infringing product. I mean, that was the point and impact of the Supreme Court's decision in eBay. And we have recognized that damages calculations require different levels of apportionment where the infringing patented products are multi-component products rather than single formulation pharmaceuticals or a mechanical item, or where the costs of discovering the patented invention are not great. But as Article 3 courts with limited policy-making flexibility, we cannot address all the issues that Congress can, or develop the law so that the innovation incentive that Congress has espoused since 1788 can be realized in this changing world. Our patent system continues to provide a one-size-fits-all reward in an effort to promote innovation, even though it has become apparent that there is no one-size-fits-all incentive that covers all the industries in our economy. Harking back to President Lincoln's words, the patent system has added the fuel of interest to the fire of genius in the discovery and production of new and useful things. But we can strive for better. Our goal in having a patent system should not be just an exercise in trying to incentivize some generalized measure of innovation. We want to have a patent system that magnifies this incentive so as to maximize the range of inventions developed. And it must be a system that is flexible enough to, as the 1836 report said, continue to adapt to the present condition of the arts. The limits of our discovery are endless. As the 1836 Senate report acknowledged, whoever imagines that because so many inventions and so many improvements in machinery have been made, there remains little else to be discovered, has but a feeble conception of the infinitude and vastness of mechanical powers or of the unlimited reach of science or of man. Much has been discovered, infinitely more remains unrevealed. Despite the passage of over 180 years, this sentiment remains just as true today as it was in the 1830s. Congress has a constitutional directive to provide a patent system that provides rights to potential inventors so that they will have an increased incentive to explore for exhaustless treasures of ingenuity and knowledge. We are finding that the unlimited reach of science increasingly applies to a multitude of fields, each having different incentives and a different timetable for progress. As Congress seeks to promote the progress of science and useful arts, it may be time for Congress to consider diverse and flexible solutions that can better promote and maximize progress in disparate fields of discovery, rather than continue to attempt one-size-fits-all solutions that result in the pendulum of patent protection swinging back and forth without ever arriving at a desired equilibrium. My father used to say that the measure of a man is not whether he makes mistakes, but whether he is making the same mistakes a year from now. I wonder what he would say about an entire country making the same mistakes today that it made almost 200 years ago. It's time we come up with more creative solutions to break the cycle of these centuries. Thank you. Okay. It doesn't have to be about this, it can be anything. Yeah. Maybe that is the answer, you know, I'll have to build that into this speech. It's the first time I've given it, so I don't know. But I think that some of the things have been thought through pretty well. I think that one of the things that shocks me is that the AIA didn't exempt pharma patents that are subject to ANDA, or biomedical devices that are subject to the Biosimilars Act from inter partes review. And the reason is that those two acts really represented very detailed, thoughtful back and forth about how much protection was really needed for that particular industry, and how much we can take away from it and allow for generic copying to ultimately allow for less expensive products to be put on the market in the interest of the public. To have those kinds of detailed acts out there that did that careful back and forth with the entire industry, and then to basically throw the baby out with the bathwater. I mean, you know that in inter partes reviews, what's happening with the pharmaceutical and biomedical industry is that it's mainly being used by venture capitalists to affect the stock price of the pharmaceutical companies rather than to actually address the validity of their patents. So I do think that you're right, certainly in the AIA, one size fits none. I would agree with that. But I think before that, we had some at least nuanced development with respect to certain industries that we were looking at, and we've sort of forgotten that.
Yeah, are you confident that Congress has the ability to deal with this entire subject matter with nuances as we do? And if not, I'm very skeptical about this. Does the federal circuit have the ability through tinkering with the nuances of obviousness, for example, to, in a sense, develop a line of case law that is more industry specific?
You must have been listening to Craig outside in the hallway, because we were having some of this discussion. I think you're right. It's dangerous to always trust Congress, just because so many things, as you understand, often compromises end up not working for anybody. One of my problems is that I do believe that the Federal Circuit, as an Article III court, has a limited policymaking function. Now, not everybody on my court is as conservative as I am about that. I am very much a believer of our place in the system, that they should respect us, we should respect them with respect to our different roles. I certainly think that Congress could address the basic question of whether shorter protection should be allowed. But I do think, and I alluded to that, that the courts are starting to do some of those things. And you're right, and Craig pointed out, even in our obviousness law, we are recognizing to some extent that things are more obvious, especially in those instances where the technology is fast moving. I'm still not sure how this 101 world is playing in. I think the 101 world is kind of as they say, a coarse filter, but it's a coarse way of trying to accomplish what I think the 67 report would have had us accomplish, which is to do away with at least most programming-related inventions, though not all. So I think you're right. The courts can do some, and I think you're right to be skeptical about Congress. I think Congress could go back and fix some of the problems in the AIA. They could create a standing requirement. They could require them to use the same burden of proof. They could require them to use the same standard for claim construction. While the Supreme Court endorsed the different standards for claim construction, the only explanation I've ever heard from the PTO as to why they do it is that, well, they're just used to doing it that way.
Well, how much do you think that's impacted by the one-year time limit under the statute for completing an IPR and the staffing of the PTO? That's got to be a tremendous constraint on the PTO to try to get those things through, and just causes them to tend towards fast solutions.
Well, I mean, I think it is a constraint. I'm not sure that the wrong claim construction gets you to a faster conclusion in my mind, but it gets you to more invalidations, but not necessarily a faster conclusion. I think that those that I know that were involved in the AIA actually envisioned a system that was much more like the ITC, where there would actually be a meaningful, real exchange and dialogue. I think that they did not really think that a, quote, trial would be no more than an hour with no discovery and virtually, no interaction with respect to witnesses or even any real back and forth. So I don't know that it's really the implementation is exactly what those involved in its passage intended. And I know there are some proposals for what they call an AIA fix. I don't know that they'll be able to fix the standing question because they like the idea that the public can come in and complain about a patent, but they don't realize that the only public that's coming in and complaining about it are those with different kind of vested interests. Yes.
I'm going to pass the mic around because this is being webcast, if you don't mind.
Okay.
I'll take the microphone. Thank you. Where's the question going? Okay, thank you.
Hi, Your Honor, and welcome back to Cleveland.
Thank you.
You mentioned the different standards in the USPTO, particularly in inter partes review and in the federal courts. My question for you is, how often in practice do you think that the standard is truly different? Whether it's really, is a interpretation unreasonable, or is it the plain and ordinary meaning?
No, I can tell you that, for instance, Judge Chen of our court thinks that probably it only happens at the margins, that it makes a difference. I've seen enough cases where I have said that your review of the claim construction, in my mind, whether the claim construction was right or wrong, depends on which standard you're using. Because it really is a much broader view, and it will have the result of invalidating many more patents based on anticipation or obviousness. So I don't know that it's always different because, we do have cases that say broadest reasonable construct, that there's still an R in BRI, that it has to be reasonable. And so it has to be, at least within the bounds of reason as you look at the specification and the other intrinsic record. But having said that, I think it makes a difference enough times. And I do think there's no reason. I mean, I understand the Supreme Court said they could do it, but why shouldn't we have one standard so that the district court understands when the PTO makes a decision what it means, so that we can just be using the same standards when we're reviewing those things on appeal? It doesn't make a lot of sense to me. And I can tell you, having just been in Europe, that our European counterparts are just, they laugh at us. They think it's crazy.
First of all, thank you for a very fascinating talk. My question, it's going to sort of the suggestions that you were raising about perhaps with respect to different fields of innovation, maybe having some flexibility there with, I guess, with regard to how long we can have exclusive licensing. I think to sort of the biotechnology field where obviously we have large corporate interests that wield incredible monetary and intellectual capital. How do we strike that balance between those institutions and not-for-profit academic institutions whose revenues from that licensing sort of become more of a significant source of income? How do we strike that balance between sort of academia and corporate use of those?
Well, I think that it is true, as I said, that we need to recognize that the small inventors don't always have the same ability to make money off their inventions. And we don't necessarily even want them to be doing that. I mean, I had the privilege to meet Dean Kamen very recently, and I know you think of all of him, you think of him about the Segway, but he had so many inventions that had nothing to do with that, and that were all based on medical inventions designed to help those who are disabled and those who, in fact, the Segway was originally designed for that. But he said that his very first invention was a clever one relating to diabetes, and he said he tried to manufacture it and to market it, and he wasn't good at it. And he didn't like it, and he found that he kept thinking of the next idea down the road, and he finally realized that he was better off if he could get a patent, license that patent, and put all that money into the next invention. And that's really what we want small inventors to do, and that's what we want academic research facilities to do. So the notion that we just shouldn't have patents, which there is some broad belief that we'd all be better off and technology would move a lot faster if we didn't have them. I think there's a reason that every time anybody's ever studied it, they come up with the conclusion that a strong patent system is important. They just have a hard time defining what a strong patent system is. So I do agree with you that there is that differentiation. But even with big biomedical and big pharma, I think what you're talking more about is fighting them in litigation, and that they have different resources for purposes of fighting litigation. But even big pharma has to spend a ton of money to go through all the clinical trials and so usually they're actually working with some of these small inventors to undertake all the additional research. I think it's really, it becomes primarily the tech world versus everybody else. And I don't mean that as a bad war. I mean, it's just that those involved in the tech world really believe that the best way we can promote innovation is to take what you have, put it out there, and allow us to just slightly design around it so we can move to the next great iPhone, whatever. And so that's where the battles come in. The guy who started Qualcomm, I heard him speak recently, and he said, I'm in the tech world. I'm one of those people that everybody files lawsuits against, and I should hate patents. And he said, but I wouldn't be here today without patents. So I get it. I get that in the beginning you have to have patents to incentivize people to build these huge companies and to then create a world where these great ideas can move forward. I don't know all the answers, but I know that we have to figure out a way to recognize that there are legitimate interests on both sides. And instead of just saying, okay, you win, or you win in terms of what our patent system's going to look like, we need to find ways to make it flexible and creative.
Given the pace in Congress and enacting legislation, and then also having the courts really limited to issues that come between them to decide, do you think there's any possibility of implementing quality control more at the USPTO level? Whether it's some system like how trademarks are examined, having patent attorneys in the USPTO doing examinations?
Doing trademark examinations?
Doing patent examinations, like the trademark system where they have trademark attorneys. rather than just the
I think
examiners?
that a lot of the PTO, oh, I see what you're saying, having the examiners
Right,
be
be
attorneys. You know, that was one of the points I made about one of the early acts where they said, let's give the PTO a lot more money and then have an education system, all of that ended up in the AIA. I didn't actually state that because I thought everybody probably knew what was in the AIA. But that whole thing about proposing more money and more examinations and that the PTO money shouldn't get diverted ultimately reared its head in, you know, in the AIA. And I think that's what they're trying to move toward. I mean, I had some young lawyers that came to work for me who said that they were examiners right out of college before they ever went to law school. And they said it frightens them now to think about the patents they were granting or denying. But it's not that examiners aren't good and that they don't work hard. It's just I don't think they're given the training or the resources. And I think that you might be right. Maybe attorneys with technical background should be doing the patent examinations. I think that makes a lot of sense. I've never thought about it quite that way, but that's a good proposal. And trust me, there are plenty of tech attorneys out there right now. And we're making more of them, right?
What did Lincoln get his patent in? I forget.
A boat. Wasn't it a boat? It was a boat, but I can't. It was a boat. Yes, over the shoals. Right.
The Scientific American came out with an article saying we hope he's a better chief magistrate of the country than he is an inventor.
Right. He got the patent, but of course, he probably got that when they were granting them all, as a matter of course, right? But it was a boat.
Question.
I've forgotten, what is the current status of the genome, the human genome? Has that been patented? I know there was talk about it. I just don't follow it, so I just wondered if, since we have a few minutes.
Yeah, well, there's right now there's a lot that's going on in the you know, the world, not just the tech world, but the legal world, about the patentability of things that can be found in nature. And there are a couple of Supreme Court decisions that said things, certain kinds of you know, discovering DNA. If you discover a particular DNA, that's not patentable. They even had cases where we said if you discovered but find a use for it that's unusual, that should be patentable, and the Supreme Court disagreed with us. So there's, you know, but there's still patent sequencing, for instance, that's deemed patentable, and so there's a lot that's still working its way through the courts in terms of. And that, I think, that's a very sensitive subject for some of the judges on our court who truly believe that those Supreme Court decisions were wrong, and that they actually, rather than promote medical innovation, will actually slow down the process of the innovation. But you know, the Supreme Court just seems to have a different view than our court on a lot of what should be or shouldn't be patentable. But there are these exceptions, including things that are found in nature, which they say even if you can't find them very easily, they're still found in nature.
Time for a few more.
I've got a procedural question. As I recall, when the Federal Circuit was first formed, it adopted an internal operating rule that provided that when, in the case of competing decisions, the earlier precedent prevails. Is that right?
Mm-hmm.
And at the time, that struck me as somewhat at odds with concepts of the evolution of law under stare decisis. And I'm not sure it's an internal operating rule in all the other circuits as well.
Oh, I think it is. I think every circuit, yeah.
Okay.
You're bound by what prior panels say until you sit en banc.
Okay.
And the reason we sit en banc as often as we do is we don't have other circuits to bounce this off of, or the Supreme Court to resolve circuit splits. So we have to sort of create our own circuit splits or try to resolve our differences within the circuit. But I think virtually every court does that. And it's frustrating sometimes because you can see, I mean, I've often written something very short saying we're bound by this, but we shouldn't be. Right. Sometimes that works and sometimes it doesn't.
Not all intellectual property is technical or mechanical. Do you have anything to comment on copyright law?
You know, we don't see copyright law as much as other courts do. We've had some big copyright cases. We had the Google Oracle copyright case, and it's coming back to us. I thought that was interesting that the 67 Act, which I think was incorporated into law in 1973, which is what I said, and Google Oracle made it clear that programming code is covered by copyright law. And I do think it's interesting because I get, we'll get all these briefs in a copyright case saying, no, leave that to the patent world. And in the patent case, they say, leave it to the copyright world. But I do think that copyright, there's a lot going on in copyright. I mean, a huge amount of change going on in copyright. And, the Supreme Court, I think, is likely to take a case out of our court with respect to, international patent exhaustion to compare whether, sometimes the Supreme Court says copyright and patent are similar. Other times they say, well, they're not so similar. So I think that as the evolution is occurring in copyright, they're also trying to look at those issues to see the extent to which they import or don't import into the patent world. And of course, there's all kinds of stuff going on in trademark. The Supreme Court just took the case of the slants case that we had, which said that the portion of Section 2 of the Trademark Act that says that anything that could be, that anyone in the community would feel burdened by, or some phrasing that would hurt the community, is not subject to trademark registration. So it's kind of like the Redskins case, or whether or not the Indians should be allowed to wear their uniforms in Canada. We said it was unconstitutional. The majority said straight up on its face, unconstitutional under the First Amendment. I said it was unconstitutional because it's void for vagueness. And so they've taken that case, which would pretty much decide the Redskins case, I think. But so there's a lot going on throughout all areas of IP. I wish we had all the copyright cases. It would be a lot more fun for me.
If you want to visit with the judge's reception, immediately following outside in the rotunda. In the meantime, guys, thanks very much. Yeah.